that is a good question. That is a question we get on the hotline all the time. And the answer, one thing I tell people is I live in a house that was built in 1926. And I'm quite sure that in the last 94 years, everything in my house has been repaired. And if I had to disclose everything that's been repaired, the disclosure would take, forever. And so obviously the answer is no, you don't have to disclose everything that's been repaired. But what do you have to disclose? And when do you have to disclose it? The one thing you got to make sure of in a situation like this is if you don't want to disclose it, you better make darn sure that the repairs were completed completely by a competent person. We get all these situations where the seller makes the repairs themselves, and are they qualified to make those repairs? And I think that's troublesome. But if you decide not to disclose something, you better make sure that the repairs were completely done by someone who's competent. If the repairs have been completed and it's fully done, I don't think there's a duty to disclose it. That's not to say that I don't recommend if the thing was major. Let's say there was a big fire in the house, a huge fire, and it caused extensive damage, and it's been fully repaired. That buyer is going to end up living in that neighborhood and knowing their neighbors, and the neighbors are going to say, "Oh, you should have seen that fire." And if the buyer says, "Well, I never heard about it," you may end up with a problem. And so I think a situation like that, sometimes it makes, if the damage was substantial, even if it's been fully repaired, there may be a good reason to disclose it, just to say, listen, this work was completely done. Here's who did it. Here's the proof that it was done. You're going to hear about it. Is there a duty to disclose it? No, not if it's been.
Thank you for that, because that's my practice. I rather put it out there so that this way we don't have to have a discussion about it later. I mean, if it's recent, like you said, you're not going back historically, but I think that sometimes it's the timing of something. So if it's that recent, right, or that if you feel obligated to ensure that it was done correctly, that it just avoids any sort of misunderstanding down the road. Like you said, for example, if the house burns down, well, not burns down, but it was, significant fire, and then someone feels that they were robbed of that information, that might have been a decision-making thing for them, that they may have made a different decision about purchasing the house if they knew it on fire.
And, disclosing completed repairs is something that you probably ought to have a discussion with your seller clients about, because if you're disclosing something that's been repaired, your client could say, well, you're stigmatizing my property. And you can have a conversation with them about why they might want to do it anyway. Because, if they truly have done the repairs and they've been completed, then, then there really shouldn't be any stigma associated with the fact that there was a prior problem. So,
hey, Bill. This is Brett again. That brings up another piece. I've seen agents put stuff in agent-only remarks that I don't know if they've run by the seller to check, because it puts their property in a big negative light. Would you say it's a good idea to always send the draft listing that you plan to put in MLS for remarks and agent-only remarks to the seller, so they're on board with what you are going to tell others about their house?
Yeah, I mean, I'm not a broker myself, and so I don't know what the practice is, but that sure seems like a good idea to me. Yeah, I think that would be great. What could be the downside of doing something like that? So yes. Let me just move on. Just a couple other things. What about the existence of a backup contract? You have an offer, or you have a contract. You put on the MLS that it's under contract, but you're still accepting other offers, and you get somebody else submits an offer with a backup contract addendum, and you enter into the contract, and it's a better deal, frankly. Do you have to disclose to buyer number one that you've got a contract with buyer number two? Well, the answer to that is absolutely not. There's nothing about that that's material, as far as buyer number one is concerned. I mean, it certainly will affect how the seller will deal with buyer number one in terms of demands for repairs and things of that nature, but that is not something that you have to disclose. It doesn't affect the seller's ability to complete this transaction. So it's not material and not a material fact. Appraisals, an appraised value, is that a material fact? No, generally not. I mean, there were some limited exceptions, and I haven't kept up with the VA and FHA rules on this, but generally speaking, an appraisal is just one person's opinion of value of a property at a specific point in time, and it is not a material fact that you have to disclose to another buyer. Just a couple other points on material facts. There's actually a publication that's available on the Real Estate Commission's website that talks about a duty of agents. Not only, I think agents know you've got to disclose material facts to all parties to the transaction, not just to your own client, but to the other parties to the transaction as well. But this material fact publication talks about the duty to disclose to the buyer's lender. So let's say you've got a buyer needs a loan, and you do an inspection. The inspection reveals all kinds of problems with the house, and maybe you get into some repair negotiations. Does the buyer's agent, or the buyer for that matter, have a duty to tell their lender about the problems with the house? And the Real Estate Commission actually has something published that says yes, but I question that advice, and I don't think that obligation exists. I think agents' duties to a buyer's lender are very limited. Short sale situation, there's a duty to let the lender know if they're considering a short sale, an offer in a short sale context. You've got to let the lender know if any other offers come in. There is that duty. The Real Estate Commission has said that exists, and I think that's reasonable. But other than that, no. So a related subject that Colleen mentioned might be good to talk about is inspection reports. What are your duties regarding an inspection report? And this typically comes up in the situation where you got a house listed, it goes under contract, the buyer gets an inspection, reveals all kinds of problems, and the buyer backs out, either because of the problems associated with the inspection report or some other reason. And then you get a new buyer interested, or even, do you have a duty to disclose some of this stuff in your, what do you have a duty to disclose? And the fact of the matter is, under the Residential Property Disclosure Act, if you complete a residential property disclosure statement and then you discover something new, or there's a change in the condition of the property, you have a duty to update your residential property disclosure statement. So if there's something in the inspection report that truly is material, that says the roof is about to cave in, I mean, or they discover a leak, or some system isn't working properly, you've got a duty to disclose it. Or maybe, they could even, I think there's disclosures in there about the age of the roof and the age of the HVAC. If you learn that those are wrong, you've got a duty to update it. But what about the inspection report itself? Do you have the duty to turn it over? The answer to that is no. You don't have to turn it over. But if there's anything material in it, you do have a duty to disclose that as the listing agent. Your seller may not have that duty, but you do. What about turning over the inspection report? Can you do it? The issue here really is copyright law, and perhaps, a lot of these inspection reports, the inspectors, they charge their, $500 or whatever they charge, and then they say, this report is for the buyer's use only, cannot be shared with anybody other than perhaps the seller. Is the seller and the listing agent somehow bound by that? I can't give you a legal opinion on that, but I think that there's some concern, but frankly, I think that if you didn't enter into any agreement with the inspector, and if the buyer agent gives you a copy, I think you're free to turn that copy over. Now, what you can't do is copy it. And, in copyright law, you can kind of liken this to if you buy a book at a bookstore and you read it, you're perfectly free to give it to your best friend to read. And you can even trade it in at the local used bookstore and get paid for it. But what you can't do is photocopy it and sell it. You can't copy a copyrighted work. You can give it away. And so I think the same thing is true with an inspection report. You can't copy it, but you can, we think, turn it over to someone. So I don't know if there's any questions about that.
So sending it via email, is that safe to do versus sending it, because I mean that's pretty much copying it.
Yeah, I think it is. I think it's, I think if you had a hard copy back in the day and you could put it in the mail and that wouldn't be copying it. And so email is replaced mail as a way of delivering something. So I would think it is okay. Now, again, this gets into that whole issue of stigmatizing your client's property. Most inspection reports have a lot in them that are not material. And, so here's one thing that I would suggest with inspection reports is if you have an inspection report that's like really long, it's got a laundry list of things that are wrong, to deliver that to anybody else might stigmatize your client's property. But what you can do is maybe take some excerpts from it and forward those to a buyer agent and say, listen, there was a previous buyer who got an inspection. Here are some of the issues that they found that we think are, more substantial than others. We encourage you to get your own inspection. There's case law out there about, what is the liability of sellers and agents for failing to disclose facts about a property. And North Carolina, which is a very defense-oriented place, it's a good place to be a defense lawyer. It's not a good place to file lawsuits. They are very protective of sellers and listing agents. And they basically say, listen, caveat emptor applies in a lot of situations. Let the buyer beware. The seller, as long as the seller gives the buyer the opportunity to do their own investigation and doesn't discourage the buyer from doing that investigation, the buyer won't be heard to complain about the fact that the seller didn't tell him what was wrong. Well, our contracts are set up with a whole due diligence thing. It tells the buyer, here are the things you should do. And as long as the listing agent and the seller say, don't limit the buyer's ability to conduct their due diligence, don't discourage the buyer from conducting their due diligence, you're going to be relatively safe from a legal liability standpoint. All right, another subject, and gosh, Colleen, I'm not getting anywhere close to covering all of this ground. Termination of agency agreements, termination of contracts. Let me start with, we get a lot of questions about proper termination of contracts during the due diligence period. I'm involved now in a really messy situation where husband and wife own a piece of property, vacation rental property, actually down at the beach. And the wife wants to sell. The husband doesn't really want to sell. He loves the place. But the wife convinces the husband to list the property for sale. They do. They get an offer. And I think the husband really was reluctant about signing the contract. But he does, and he agrees to sell the property. Well, once you're under contract, the seller has to sell. There are very few ways for a seller to get out of a contract to sell. And one of the buyer's remedies is specific performance. They can actually sue, the buyer can sue the seller for specific performance. Well, in this case, there was inspection done, repairs were needed. There was a verbal agreement where the seller said, okay, well, I'm not gonna do the repairs, but I'll give you a $4,000 credit or reduce I think they were talking about either reducing the sales price by $4,000 or seller paid expenses at closing was going to increase by $4,000, whatever. But the husband would never sign the documents to document that $4,000 adjustment. And so the buyer the buyer's agent sent a termination form, but the form that they sent was not Form 3 in the 350, which is the unilateral termination form. They sent the 390, which is the termination by mutual agreement. And the termination by mutual agreement says this termination is effective when it's been signed by both parties. Well, the seller wouldn't sign that either. And so he wouldn't sign anything. And by the way, the buyer agent, when she sent the termination form, she said, listen, my clients don't want to terminate. So seller, either sign the due diligence repair agreement, which had the $4,000 adjustment, or sign the termination, sign one or the other. And the seller told his agent, well, look, I can't make up my mind. I'm going to the beach to decompress. What I suggest is let's extend the due diligence period by a week. And so she sent him a form to extend the due diligence period by a week. He wouldn't sign that either. And the buyers got so frustrated that their lawyer sent an email to the listing agent saying, we withdraw our Form 390, our offer to terminate the contract. We're ready to close. And the seller says, well, I don't want to close. And the buyer has sued the seller for specific performance. The moral of this story is, if you're a buyer and you truly want to terminate a contract, during the due diligence period, and have the right to terminate the contract, use the right form. Use the form that's a unilateral termination form. It's 350, there's 351 and those, if you're the buyer, it's 350 and 351, depending on it's residential or vacant land. Now, the truth of the matter is not any specific form is required to terminate a contract. And so if you use the wrong form, it's still possible that your termination would be effective. And there's articles out there. There was an Insight Magazine article and a Q&A out there that you might find that talks about, like, what if the buyer agent sends the wrong form by mistake, but makes it clear in their cover email, buyers are terminating. It's clear, absolutely. We are terminating this contract during the due diligence period, but they send the wrong form. That could still work. But in the case I just told you about, the buyer agent did absolutely the opposite of that. The buyer agent's email said, buyers do not want to terminate, but they're willing to do one of two things. You pick. And when the seller refused to do either one, they withdrew their offer to terminate. Okay. Another termination issue comes up with agency agreements. Can agents or clients, for that matter, terminate an agency agreement unilaterally? And what we've talked about in the past is, you can terminate the agency relationship unilaterally. So if, let's say, a seller, they're going to move to California for a new job and they list the property with you, but then the job falls through and they decide not to move, they can tell you, stop marketing my property. I don't want to sell. And they withdraw your authority to market their property. Well, they've terminated the agency relationship. But what they haven't terminated is the agency agreement. And so what that means is they can't, after telling you that they don't want you to market the property, they can't then go out and sell the property to their neighbor and not pay you unless the agreement itself is terminated. And then the question is, so can they terminate it unilaterally? Well, in both the buyer agency agreement and the listing agreement, there are termination provisions, and it talks about the fact that it may not be terminated by the seller or the firm prior to its termination date without legally sufficient cause. So what that tells you is, if you have legally sufficient cause, yes, you can terminate, whether you're the client or whether you're the agent. What's confusing to me about both of the agency agreements is the next sentence reads, any such termination shall be by mutually acceptable written agreement signed by both seller and firm. Well, that makes it sound like even if you have cause, you can't terminate unless you get your client to sign the termination form. And if you've got a client that's mad at you, they won't sign that termination form. And so I just got to tell you that language, if you're terminating by agreement, use the agreement. But if your client won't agree and you want to terminate because they are a complete pain and they won't cooperate with you and they're not doing things that they need to do, you have the right to terminate unilaterally. Colleen, unmute yourself. You want me to talk about some hotline issues? You want me to talk about some real estate commission cases? You want me to take Q&A? Do you want to go till 11? What do you want to do?
I'd say, why don't we go like at least 10 or 15 more minutes? But I'd say whatever you can cover in the like, if you've got quick topics, any cases, maybe you could just touch briefly on those.
Okay. Yeah, I mean, I've got a few cases that might be interesting to talk about, and these are things that I'm currently handling, that are currently being dealt with at the real estate commission level, and are, I think none of these cases are resolved, so they certainly haven't been in the bulletin.
And feel free to mention my case, because I think that's a case that all of us as realtors have, breach of contract, have run across. And Bill represented me in a case that lasted for 5 years and won it. And he was the best litigator and really was passionate about it. And also the legal North Carolina Association of Realtors, they have a fund that will support realtors out there that are standing up and having to pay the court fees, and they actually supported my case and paid for part of the legal fees. So make sure that you all know about that being available to us, and as well as the hotline, and Bill is, his and Will's service.
Yeah, I talked about the hotline at the beginning, Colleen, before you got on. So let me talk briefly about Colleen's case, and the legal hotline. So Colleen basically was in a situation kind of like what I just described. She listed a property for some clients, advised them to do some things to get the house ready for sale. Clients consented to dual agency. She knew some people that were interested in the house. They looked at the house. They were ready to make an offer. She had them, before they made an offer, they had to sign a buyer agency agreement, which they did. It was limited, I believe, the buyer agency agreement, to looking at they were just going to compensate her for this house. Colleen wasn't going to represent them for anything else. And they consented to dual agency. They submitted an offer. The offer was rejected. The sellers then told Colleen that they no longer wanted her to market the property. She sent them a proposed termination agreement, which has release language, if you're familiar with the termination of agency agreement. But it was unsigned. I mean, that's the key thing. Colleen had not signed it, because here these people had changed their mind from listing their property to not listing their property. She figured they might change it back. So she sent it to them unsigned. A few days later, these buyers put a note in the seller's mailbox saying, we're still interested. Maybe we should talk. Well, the buyers didn't tell Colleen about that. The sellers didn't tell Colleen about that. But what happens without Colleen's knowledge is the buyers and sellers start talking to each other. And, oh, by the way, when Colleen sent the termination form to these sellers, they signed it and sent it back to Colleen, but Colleen never signed it. She held on to it. So the buyers go ahead and make an offer to the sellers without using Colleen. And they submit a written offer. And that was on May 9th. The sellers received the offer. They immediately contact Colleen, because they know this termination form is out there. And they say, Colleen, you never signed that termination form. Send it back to us, will you? And they didn't tell Colleen that they had a written offer in hand from her buyers. So Colleen says, well, it's been 3 weeks. She goes ahead and signs the termination form. And that form says that Colleen and her firm are completely releasing the sellers from everything. That was on May 10th. On May 11th, the sellers signed the buyer's offer. A month later, they close on I can't remember, the $1 million house.
1.5.
1.5, big house. big commissions, I don't know, 60, 70, $80,000 commission was a big commission. And Colleen finds out about it and she files a lawsuit. She doesn't hire us, but she hires another law firm and they go after she initially sues both the buyers and the sellers. And she eventually drops the buyers, but the court in Raleigh in Wake County rules against Colleen. And that's when she comes to us and she says, I think the court got it wrong, don't you? And we absolutely thought the court got it wrong. And so we said we'd be happy to handle the appeal. But not only that, we told her about the Legal Action Fund, which is an NCAR fund that's available to help realtors finance litigation, because litigation is expensive. And I like to think we're relatively reasonable in our fees, but it's still expensive on a case where you're going after even a $60,000, $70,000, $80,000 commission. And so they only will take cases that will have if they get reported, will have an impact on the entire realtor nation. And so Colleen, and I think Will, or maybe just Colleen, made a presentation to the board of directors of this legal action fund, and they agreed to finance the litigation, basically pay our fees. I don't think they paid any of Colleen's prior fees to the lawyers that handled the case in the trial court. But we filed an appeal, and our basic argument was every contract that parties enter into has an implied duty of good faith. And the sellers in this case, by asking Colleen to sign that termination form, when they had a written offer in hand that they intended to sign, they did not act in good faith. And so that agreement, that termination agreement with release language, should be considered void. And the Court of Appeals agreed with us, issued a very helpful decision. I didn't get to have oral argument there. They took it just on the briefs. And the other side, not wanting to pay, despite the ruling by the Court of Appeals, took that to the North Carolina Supreme Court. And I got to argue that case in the front of the North Carolina Supreme Court. And Colleen was there. I mean, one question, the other side got up and argued. And within like 5 minutes, it was obvious we were going to win that case, and we did. And all of her appellate legal fees were paid for. So, it's an interesting case from just, you can recover your commission if you're getting screwed by a client. That's one lesson to be learned. The other lesson to be learned is there is a fund available in certain cases to help you finance the cost of litigation if it doesn't seem worthwhile. I mean, I can't guarantee you that you'll get funding, but that it is possible.
Yeah,
Anything
I think
further on that, Colleen?
points, and I think the fact that the legal counsel, when I presented my case in front of the North Carolina Association of Realtors, not legal counsel, but it was the board of directors. They stood up and they unanimously said, who doesn't have someone in their office that is dealing with this same thing right now? So they unanimously, offered the funds or agreed to it. And I think we all, as Small Broker Council, we need to make sure that we're aware that this is available to us.
Right. And if you want to find the case, you could probably Google Blondell versus Ahmed. It's a publicly available document. So interesting. Might make for interesting reading. Just a couple of, let me just talk about a couple of real estate commission cases. I mean, Colleen, do people have to get off at 10:45 or?
I'm not sure. I think if they want to get off, we normally quit it. Then we've got a few announcements, but yeah, if you want to zip through a few more, we don't want to, we want to be respectful of your time too.
Well, yeah, I'm good. I was a couple of just cases to talk about things that are going on, things to think about. I'm representing a client right now who's a buyer agent who had a client who was going to move down to Charlotte, was going to buy a very nice condo, like $800,000 condominium. Initially, she was talking about moving in, but then she said she might be interested in renting it. And at one point, she asked my client for the restrictive covenants because it was in a condominium. And so my client was a member of Canopy, the Charlotte area MLS, and they provide something called CRS, the Courthouse Retrieval System. I don't know if y'all use it in the Triangle, but it's a system that, among other things, gives you access to things like restrictive covenants. So she uses it, she puts in the address, and it comes up with 2 documents. She sends those documents to her client. And the client sees them, and ends up closing on the property. And shortly after she closes, discovers that she is not going to be permitted to rent her unit, that there was an amendment to the restrictive covenants that was recorded in 2011. And for some reason, this courthouse retrieval system did not pick it up. And so she hired this aggressive law firm. And this law firm is going to sue because my client knew that there was some interest in renting the property. She was asked to provide restrictive covenants, and she did, and she didn't find something that impacted her client's ability to rent the property. But instead of filing a lawsuit, they started with a real estate commission complaint because they want the real estate commission to find that my client screwed up, and then they can use that finding in any lawsuit that they file down the road. So I'm defending my client in that case. So in trying to just as an aside, is trying to negotiate a resolution in this case, the real estate commission said, listen, your client missed something here, but if she's willing to, so we want to suspend her license for a year with 3 months of it active. But if she's willing to refund her commission on this deal to the client, we'll just give her a reprimand. Well, my client doesn't even want a reprimand. But she figures, well, look, I'll see what the deal is. So she goes to the law firm for the buyer and says, we're willing to try to settle this with you for a release. If you'll release us from any liability, what would it take for you to get what do you want from us? What do you want from my client? They come back and their settlement demand is essentially $800,000. $800,000. That was the purchase price of the condominium. They're now willing to sell my client the condominium for $800,000. They want to keep the condominium and $800,000. So we've gone back to the real estate commission and said, this is what they're demanding. We think you should dismiss the case because these people are using the real estate commission as leverage to try to get a huge resolution out of, a huge settlement, huge payment out of my client. And the real estate commission shouldn't be used in this fashion. It remains to be seen what's going to happen in that case. But the lesson to be learned here is you should not try to advise a buyer client about restrictive covenants. What my client didn't do in this case is she never asked the listing agent, what are the restrictive covenants affecting this property? She didn't tell her client to go ask the HOA or to hire an attorney to determine this. Now, I know that a lot of attorneys don't want to make representations about restrictive covenants, but I'm telling you, buyer agents who try to advise their clients about which restrictive covenants are out there are skating on thin ice. And I have I handled a very recent case. Some of that's been reported in the bulletin already, closer to Raleigh, involved a piece of property where she had clients who definitely wanted to have chickens. So every time she looked up property, she wanted to make sure there were no restrictive covenants involving chickens. She found a property. She didn't find the restrictive covenants, any restrictive covenants. The MLS listing asked, the residential property disclosure statement asked about an HOA, whether there was an HOA. Well, this particular development had restrictive covenants, but no HOA. And so they answered no HOA. So the buyer agent had no idea that there was an HOA or that there were restrictive covenants. Her clients buy the property and a neighbor comes over and says, you can't have chickens. And they were completely apoplectic about it. And it turned out there really were restrictive covenants out there. The buyer agent, who was a provisional, just never found them. And so the real estate commission not only went after the provisional broker, but went after the BIC. And this BIC had done a great job of training her people. And like any other, she actually had 40 provisional brokers under her supervision. She can't check behind them on every single thing they do. And but we were able the provisional took some discipline, like a reprimand, and the provisional broker, eventually we got her case settled for, actually it was dismissed.
You got to share the results with that case with us when you're
Yeah.
done.
So, the provisional broker has actually been reported. I'm drawing a blank on her name, Molly something. She's out of Fayetteville. Is reported in the last couple of months. Her BIC got a reprimand. So her license wasn't suspended at all. Actually, I think her case actually has got a conditional dismissal. So I think all she had to do was take some classes, and then her case is going to be dismissed. I could tell you for sure if I looked it up. I don't want to take the time, but the provisional really did screw it up. I mean, she missed something, and she shouldn't have missed it. And again, it was the same situation. This provisional broker never asked the listing agent whether there were restrictive covenants. Never asked. And that's what, so if you're a buyer agent in that situation, don't make representations, and do ask the other side, and then turn over whatever the listing agent gives you. And then all you can be accused of is handing over what the listing agent gives you. And if there's a problem, I think it's going to be the listing agent's problem.
Well, Bill, we'd probably love to have you on all day long, because all of this stuff is so interesting and so great. So we really appreciate you getting on. We apologize for the delay to everyone on the call. It just, I'm not sure what happened, but it's unfortunate. And I know some people couldn't join us because of it. So we've got a few announcements to make, just to follow up with small brokers. But Bill, thank you so much.
You are welcome.
But I wanted to bring up a few things just in closing. First of all, thank you for being on the call. We've got to choose at the end of the year. Each year, Small Brokers Council chooses a charity or a nonprofit that we want to give money towards. So right now we have the Realtor Foundation of Wake County that represents the 9,000 plus agents that are in the area on the top of the list. So if any of you have recommendations as to who you might want us to donate money to, if you want to send that either to Chris, myself, or Sam, that would be great. The Leadership Academy, the applications are, we're looking for Cara to get those applications as soon as possible. So if anyone knows anyone that might be interested in the Leadership Academy, get their applications in and or have them talk to Cara on that. So I wanted to give a shout out for that. 2021 elections for Small Broker Council Vice Chair. We're looking for a Vice Chair for next year. So we would love any of you to put your name in the hat and or nominate someone for that position. We'd really like to get that going for maybe the September meeting. And then that leads us to the next few meetings. So bringing us through the end of the year, we've got a really great meeting coming up in September. Sam had organized this. I don't think she's on the call anymore, so I'm going to just briefly go over. The September 16th meeting is on mindset leadership. It's a half-day meeting. The Zoom will work. So I'm assuming, I think we're doing this via Zoom. This is open to all our AR members, so we'll get you out more information in regards to how that meeting's being held. I'll have Sam send something out. And then the next two meetings are October 21. October 21 meeting is the business planning meeting, and we also have a really great speaker, Candace Ellis, who's a real estate teacher and coach, who's going to be leading that. And then November 18th is the last meeting, which is the member roundtable, which is always enjoyable in sharing ideas and situations that we've run across in the past, and where we can help one another on that. So if anyone else has any questions or comments, unmute yourself and feel free to speak up. Otherwise, thank you all for being on the call. And we'll look for our next meeting being September 16th. We'll send this out. And if any of you haven't joined the Facebook Small Brokers Council Facebook group, please do that, because we are sending out a lot of messages via that, as well as the emails. Thank you all again, and have a great rest of the week.